Good morning. My name is Akeem Olajide Bello. I'm a professor of public law at the Faculty of Law, University of Lagos. I want to use this opportunity to share my views on some of the issues surrounding whether defamation is a crime and whether it should not be a crime, and so on and so forth. I know that there's an ongoing public issue surrounding the alleged defamation of Chief Afewa Balola, but I will not be making any comment on that issue because, as we know, that issue is sub judice. But I will only provide some, shed some light on why the offense of defamation was decriminalized in Lagos. That's what, and then I will also provide some clarification on the legislative competence of states, houses of assembly to make criminal laws generally. Now, on the issue of decriminalization of defamation, yes, it is true that in Lagos, defamation has been decriminalized. And the reason for that decriminalization was that in 2011, I was privileged to be a member of the Criminal Code Law Reform Committee when I was serving as the Senior Special Assistant to the Governor of Lagos State on Public and Constitutional Law. And I served in the Lagos State Ministry of Justice, where I worked with Mr. Olashmo Shashore, SAN, Senior Advocate of Nigeria. Now, in that committee, we recommended to the Lagos State House of Assembly to decriminalize defamation. And our recommendation was based on the fact that defamation is already a civil liability. The law of torts provides avenue for anybody who feels that they have been defamed to bring up an action in court and get damages. And the law of tort provides adequate opportunities for anybody aggrieved to seek adequate compensation and remedies. And we felt that criminalizing defamation is an undue restriction on the exercise of the right to freedom of expression. Yes, we all have a constitutional right to freedom of expression, although we know that that right is not absolute. Section 45 of the Constitution provides that the right to freedom of expression may be limited by a law that is reasonably justifiable in a democratic society, in the interest of public, the public interest, interest of public health, interest of safety, to protect the rights and interests of others, and so on and so forth. But in the case of defamation, because the law has already provided an opportunity for adequate remedy where a person feels defamed, adopting the criminal law to criminalize defamation will be excessive. In fact, in a recent case, in Avilmo versus Commissioner of Police, 2022 4 Nigerian Weekly Law Report, part 1819 at page 69, the Supreme Court, Honorable Justice Ogunwumiju JSC, did affirm that criminalizing defamation is excessive. And we also need to note that, yes, the right of freedom of expression can be restricted by laws reasonably justifiable in a democratic society. Criminalizing defamation is excessive. And liberal democracies have decriminalized, many liberal democracies have decriminalized defamation, criminal defamation. We also need to note that defamation is one of the products of our colonial heritage, where there were provisions in our laws to restrict, the freedom of expression and the freedom to agitate for independence and so on and so forth. So now that we are in a modern liberal democracy, we felt at that committee that recommended the decriminalization of defamation that it is no longer justifiable in a democratic society to retain it as a crime. The same position has also been taken in Edo State. I was also privileged to be the legal consultant to British Council, the Rule of Law and Anti-Corruption Program, implementing European Union project in Nigeria. I was a legal consultant to a team from the Edo State Ministry of Justice that reviewed the criminal law of Edo State. And I also recommended to them the need to decriminalize defamation, and that committee accepted, and the Edo State House of Assembly also accepted it. when in 2022, the criminal law of Edo State also removed defamation as a crime. So I believe that every other state in Nigeria, including the states in northern Nigeria, where the penal code also has provisions on defamation, should take the necessary step to decriminalize defamation and allow the civil remedies to be used by anybody who is aggrieved or who claims or alleges that he or she has been defamed. Now, the other issue that I want to address is the issue of the general legislative competence of states to make criminal laws generally. Under the Nigerian Constitution, states have residual exclusive legislative competence to make laws on crime generally. The criminal code, I will state briefly the history of the criminal code. The criminal code first came into Nigeria in 1904 via the criminal code proclamation in 1904. When Nigeria became united in 1914, after the unification of Nigeria, the criminal code was then extended to the whole of Nigeria. Now, in the course of Nigeria's constitutional history, Nigeria adopted federalism. And by virtue of the adoption of federalism, the legislative powers to make laws on crimes generally devolved to the states as a residual exclusive legislative powers. And by virtue of that, all the pre-existing laws that were made under the unitary system of government that were adopted prior to adoption of federalism now devolve as state laws. So the criminal code, which hitherto was, a federal legislation, now that the legislative competence to make criminal laws has devolved on the state, now took effect as the laws of the regions, and then subsequently as the laws of the states that took over from the regions. So as we speak today, the general power to make crimes generally devolved to the state. This was affirmed by the Court of Appeal in Tanke versus the State, 2008, 16 Nigerian Weekly Law Report, Part 1114 at page 597. The court affirmed that the legislative competence to make laws generally on criminal law is residual to the state, and that was the basis in which the court sustained the legislative competence of state to make laws to criminalize armed robbery. Now, so one issue that still needs to be addressed is the fact that we still have the criminal code scheduled to the Criminal Code Act in the laws of the Federation of Nigeria. So what is the legal position with respect to that? My position is that the federal government no longer has the general legislative competence to make laws on crime. With the Criminal Code Act having taken effect by virtue of Nigeria's adoption of federalism as laws of the states, what ought to remain legally, rightfully, in the Criminal Code Act are the provisions that relate to federal offenses. What do I mean by federal offenses? The federal government has the power to create offenses on any matter on the exclusive legislative list. The federal government has the legislative competence to create offenses on any matter on the concurrent legislative list within the scope of the powers vested in the National Assembly under the concurrent list. Because even our concurrent list is a concurrent list of mutual exclusivity, meaning that even in a concurrent list, there are areas that are exclusive to the federal, there are areas that are exclusive to the state, while there are areas that are truly concurrent. So the federal government can still make laws on any matter arising from the exclusive list or arising from the concurrent list or incidental to any matter arising on the exclusive list or the concurrent list. So the current provisions that we have in the Criminal Code, scheduled to the Criminal Code Act in the laws of the Federation, are no longer, sustainable under the legislative competence of the federal government. So by constitutional process again, pursuant to Section 315, which deals with existing laws, those provisions are deemed no longer operational. The only provisions that should legally remain in the Criminal Code, scheduled to the Criminal Code Act, are the provisions that relate to federal offenses, matters like treason and treasonable felony, matters like post and telecommunications, matters like currency, and any other matter that can be linked to any item on the exclusive list and any item on the concurrent list. So the federal government no longer has the competence to legislate on all the matters currently contained in the Criminal Code, scheduled to the Criminal Code Act, contained in the laws of the Federation of Nigeria. So actually, the process of law revision that has taken place, producing different versions of the laws of the Federation, the reviewers ought to have removed all the provisions in the Criminal Code, including the provision on defamation that relates to the creation of offenses generally. Like I said earlier, the only provisions that should lawfully remain in the Criminal Code scheduled to the Criminal Code Act of the Federation of containing the laws of the Federation are matters related to items on the exclusive list and items on the concurrent list. So I hope with this brief video, I've been able to shed light on the question of whether defamation is a crime in Lagos and Edo. And only yesterday, I Googled and I found that there is a new criminal law in Ekiti State, and I tried to contra-find defamation. I could not find anything relating to defamation. So meaning also that it appears that in Ekiti State, the offense of defamation has also been criminalized. And I believe that that is the way we should go. And I urge all, the states of the Federation of Nigeria to take the leadership, to follow the leadership taken by Lagos and Edo, and I believe also now recently by Ekiti State, to decriminalize defamation. Anyone who claims that he has been defamed, the law of tort, the law of civil remedies provide adequate, remedy for any such person, to go ahead and get all the necessary remedies that they think is available to them under the law. And then finally, I would also like to make a quick comment about that case I referred to earlier, the case of Aviomo versus Commissioner of Police, 2022, for Nigerian Weekly Law Report, Aviomo versus Commissioner of Police, 2022, for Nigerian Weekly Law Report, part 1819, at page 69. Now, that matter related to an application in northern Nigeria to issue a first information report. That is an investigative process. But the matter was challenged because the offense with which the first information report sought to be issued was the offense of defamation. So the matter went to the High Court, Court of Appeal, and the Supreme Court. And the court ruled that the parties did not actually make any sustained argument or contention relating to the constitutionality of the defamation provisions under the Penal Code Act. But interestingly enough, in the lead judgment delivered by Honorable Justice Ogunwumiju JSC, she extensively discussed the jurisprudence, supporting the decriminalization of defamation. And in fact, the court held that criminalizing defamation is excessive. So she went on to discuss all the jurisprudence surrounding the decriminalization of defamation. So I want to urge that all the states in Nigeria should completely remove defamation from their statute books. Anybody who feels aggrieved should go to court and if he's able to prove his claim, obtain the remedy of compensation, injunction, and so on and so forth. Thank you very much. God bless.